Welcome. I'm Austin Abney with Berlin Patent Ebling, and we're proud to be a sponsor of today's legal update with Juana Watkins from Florida Realtors. Juana Watkins is the General Counsel and Vice President of Law and Policy at Florida Realtors. She is an experienced attorney and executive-level professional with a demonstrated history of success in the real estate industry. She built a career at the Division of Real Estate in the Florida Department of Business and Professional Regulation, first as a senior attorney and then as the division's chief attorney. From 2008 to 2011, Watkins was deputy director for DBPR's Division of Real Estate, and from 2011 to 2017, she headed the division as its director. In that capacity, she directed all regulatory operations for more than 300,000 real estate and appraiser licensees in the state, including education, licensing, investigation, and prosecution. She managed an operating budget of $5 million and led a team of more than 70 staff members located at the Orlando headquarters and across 9 regional offices throughout Florida. Watkins earned her Juris Doctorate degree from Florida State University College of Law in Tallahassee, Florida, and her bachelor's degree in Business Administration from Florida A&M University, also in Tallahassee. She first joined Florida Realtors in 2005, serving as a senior counsel and advising realtor members on legal issues from 2005 to 2008. Please welcome Juana Watkins.
Good morning, everyone. You know, sometimes I listen to these bios and I wonder, who are they talking about? But good morning. The most important part of that bio is the fact that I have the pleasure and honor of serving as your general counsel at Florida Realtors. And if you've heard me speak before, I have said that, and I will say it again today, and I'll say it if you hear me speak in the future, because I mean it no less sincerely today than if you've heard me say it before. This is an amazing industry. Florida Realtors is, I believe at this point, somewhere in the neighborhood of 1,000 members strong. And so I'm thankful to be here with you today, and I'm thankful for the opportunity to be able to come and talk to you about what we are hearing from our members. One of the duties that I have as your general counsel, I just noticed my screen is flipped, so my apologies for the fact that my background is flipped there. It's not paying honor to the beautiful logo that you have in honor of this conference. So my apologies for that. You know, I have the privilege of supervising the attorneys who work with Florida Realtors Hotline, and it is one of our most popular member services. And I joke that the hotline is fantastic because we typically get somewhere around 74,000 phone calls or emails a year. And we have seen a dramatic increase month after month compared to our 2019 numbers. And it's been on fire. And I'm happy to report to you, this is not the joking part, I'll get to that, but I'm happy to report to you that, because trust me, this is not funny, because these calls are growing in numbers. We are seeing, you know, anywhere from a 12 to 14% increase every single month. And the calls are all transactional based. 6 months ago, I would have told you our calls are COVID and unemployment, but they are all about transactions. So that tells us in real time, because they'll call us and say, you know, I was at a house this morning, or I was drafting an offer an hour ago, or I'm about to go draft an hour. So these are real time transactions. And the joking part is, it's like having 200,000 intelligence officers in the field reporting back exactly on what's happening in the industry. So we get to gather all kind of great intelligence from you all. So thank you for those of you who call the hotline, because you help us know exactly what's happening in the industry in real time. So I'm going to share my screen. We'll talk for about an hour, and then we will, give me just a moment here. We will, oh, I'm not doing something right here, so my apologies. Bear with me just a moment. We will talk for about an hour, and then I'm going to take questions that you have about anything that we talk about today or anything that we don't talk about. So give me just a minute to make sure I'm doing this right here. So bear with me. Thought I had this queued up, my apologies. Let me try this one more time. There we are. All right, so I developed a new PowerPoint for today that is focused on our top 10 common calls into the hotline for 2020. And I'm really excited about this format because it is a mini version of a brand new 2-hour continuing education course that the attorneys for the Florida Realtors Legal Hotline created at the request of President Barry to be able to offer to the members. So it's like a legal update on steroids. And so it's a 2-hour CE course. Unfortunately, today, this is not a CE course, sorry. But for those of you who may be interested in that course, check your calendar. For any association who's interested in having that course, let us know. But today is a mini version of that course. And so it is really important because it's really great real-time information. Now, when you call into the hotline, one of the things that we hope to do is to be able to talk to you about risk mitigation tools. This is very important, and let me tell you why. We can't represent individual members, right? So we're not individual attorneys for the members, and that's tough. But what we want to do is to have these educational exchanges with you about legal topics. And hopefully by the end of the call, while we sometimes can give you a yes or no answer, sometimes at best what we can do is talk you through the issues, help you identify where your liability is, so that by the end of the call, you have some guidance to help you try to understand how best to reduce your liability. That's important. And it's really important because another service that we provide for you is we attend all of the meetings of the Florida Real Estate Commission and the Real Estate Appraisal Board. And attending the commission meetings is very important because we monitor the cases, the disciplinary cases. So we hear the types of things that get members in trouble. And we come back and discuss those as a group so that we're all clear on where the commission lands on some of these topics. So when we build these courses and these legal updates, we have considered that. When we talk to you on the phone, we are factoring that into our discussions with you. And so oftentimes I have talked to members and I feel like I am the parent of this kid. And I don't mean that in a negative or a demeaning way. I mean it in a funny way, because this kid was me growing up. I saw this posted on social media one day, and the context of this is the parent told the child, do not set foot out this house. And so this child, who reminds me so much of myself growing up, found a technicality. And so they found a way to go outside, and they still honored their mother's wishes to not set foot out of this house. In legal world, when I see this, I think to myself, what this means is that at the end of the day, the judge or the jury cannot convict this child because they technically followed to the letter, the instructions of their parent. But at the end of the day, it's going to cost that child, or in our case, it's going to cost that professional service provider so much money to defend themselves when the jury pronounces the not guilty, or the judge says you're not guilty, or the FREC says you're not guilty, or we won't prosecute you. Because technically they didn't violate the law, but they got as far up to that line as they could. A good lawyer, a good business owner avoids getting up to the line, because the reality is risk management, risk mitigation is about running your business in a way that you do not that you do not expose yourself to the extent possible to any litigation or risk. All right. So keep in mind, as we talk about these topics today, I'd love to see you not be sued, right? It's not just about not being convicted or not being successfully sued. Think about ways to not be sued. Think about ways to not have the FREC complaint filed against you, or if they file the complaint, that it never even gets out of the gate. That's how you want to run your business. Some of these topics are elementary to some of you in the room, but keep in mind, if you are a broker and you've been practicing for 15 years, you may say, Juana, why are you talking to me about calculation of time? Or why are you talking to me about Wally the alligator again? Well, it's because in October and September, over those 2 months, the Real Estate Commission added 7,000 new sales associates. So if you're the sales associate who's 2 months in, you may want a refresher about calculation of time. If you're the broker who employs that sales associate who's 2 months in, be very grateful from a risk mitigation perspective that I'm going to talk about calculation of time. So here we go. I would say the top 10 questions on the hotline, just for your reference, I'm not going to go through all of these again. They're available in that course if you decide to take that course in the future, is advertising. We'll talk about that today. Good old-fashioned procuring cause, been around forever, going to be around forever because it hits to the bottom line of what you're doing and how you get paid. So procuring cause, definitely one of our top 10 calls. Commission disputes between brokers and associates, not just broker to broker, but broker and associates, where the broker says, you agreed to share part of your commission with the buyer, to rebate part of the commission. I never agreed to that, so I want my full split. You agreed to this creative marketing program, but I never agreed to that. So don't take it out of my portion of the commission. My independent contractor agreement doesn't provide for that. So there are times where there are commission disputes between brokers and associates, right? The associate leaves the office and the independent contractor agreement says that the associate will be paid for the portion of the work that they did minus any amount that the broker pays to the agent who finished the deal. And that leaves quite a bit of discretion for the broker to decide which agent gets paid which amount. So there are times where associates will call us and say, yeah, but I was the procuring cause. The other agent didn't really need to do anything. except close the deal. Well, that except close the deal may have included extensions, inspections, appraisals, denial of financing, reapplications of financing, all of these things that may have cost a lot of work to get to the finish line. Or sales associate 2 may have done very little other than literally show up to the closing. And so obviously sales associate 1 may have suspicions about what amount of work sales associate 2 actually performed to justify the split that the broker pays. So we get calls like that all the time. Duties to present offers, we're going to talk about that in detail today. Terminating of listing agreement, dealt with that today or this week in South Florida. So this is very common where a member will call the hotline and say, but the seller canceled the listing. And language matters a lot when you call the hotline. So we may drive you crazy because we'll say, well, what do you mean by canceled? Do you mean cancel? Do you mean conditional termination? Are you talking about cancel the listing agreement contract? Are we having a discussion about the status in the multiple listing service? What do you mean by withdrew the listing, right? So we have that conversation very frequently on the hotline. So termination of listing agreements is a common call that deals a lot with commissions, listing contracts, the multiple listing service status, and sometimes FREC issues. So that's common. Unresolved legal disputes of all kinds, usually associated with a contract that does not close. Lots of questions there, I'm sure you can imagine, and the factual patterns are very, very unique from question to question, or from transaction to transaction. Calculating time. We're going to talk about that today because that is a huge percentage of our calls right now, particularly with the number of new agents that we have, and not just the calculation of time, but the failure to perform within the necessary calculated time frame. Okay, so that's the second step of that. Commissions being renegotiated within the contract itself and how to handle that. We get lots of calls there. Referrals for unlicensed persons, business, they helped me out. I wanted to give them something in exchange. They send me a lot of business. I want to help them out and give them something in exchange. Maybe it's an unlicensed person that they know. Maybe it's another service provider, and then we end up in RESPA world. So that's common. And then emotional support, that's not common to pay, let me be clear, but that question is common. So that's a big set of calls. And then emotional support animals, I'm at the risk of sounding like I'm committing animal abuse. I'm going to beat that horse a little bit more today. So those are our top 10. So I'm going to cover a couple of those topics in detail today. In advertising is where I'm going to start because it gets into FREC world, local board world, MLS world, fair housing world. So let's talk about advertising because it is an area ripe for liability and an area where as brokers and even agents, you want to consider some major risk mitigation techniques here. Okay, so from a FREC perspective first, there is an individual advertising rule that has been around forever, has not been changed very much in a decade or more, maybe 20 years. It looks pretty much the same as it did when I entered the industry in 2001. It is Rule 61J2 10.025, the Real Estate Commission's individual advertising rule. If you hold a license of any kind under the Real Estate Commission, this rule applies to you. So it says, these are the highlights of this rule. All real estate advertisements, all, okay, must include the license name of the brokerage firm. Well, Juana, I'm a sales associate, I'm an independent contractor, and I want to hand out stylus pens. And they limit the characters that I am allowed to print. So I just want to put my brand as a sales associate, not my brokerage name, because I don't have enough characters. The Real Estate Commission would say, then that is not the vehicle of advertisement that is available to you. Okay? So if it is an advertisement that you choose to use, you must comply with these requirements, or it is not a vehicle that is appropriate for you. Before Twitter expanded its character count, I was still at the Real Estate Commission. I used to hear all the time from people who used to say, but I can't get enough characters in the tweet to talk about the property and do all these things. Then I would say, then that is not the vehicle for you. Okay, so it is not going to be an excuse or defense that you didn't have enough characters. No advertisement placed or caused to be placed by you shall be fraudulent, false, deceptive, or misleading. Why did I say placed or caused to be placed? My marketing agent did it, not me. They've heard that before. That's not going to work. My assistant placed that ad, not me. That's not going to do it. That's why they say placed or caused to be placed, because that person was providing services for you. So make sure if you employ someone to do this for you, or you contract for services, they understand the requirements of the rule. When the licensee's personal name appears in the advertisement, at the very least, the licensee's last name must be used one time. Okay, so I'm Juana Watkins. I want to be personalized in my ad because it just sounds better. I want to be Juana to the homeowner. Then you can be Juana. For instance, my maiden name is Carstarfin. Who wants to use Carstarfin? Who wants to put that in an ad? Okay, Carstarfin. Well, if I want to use Juana, I got to use Carstarfin at least one time. I don't have to put Carstarfin every time, but I got to put it on there at least once. Okay. When the advertisement is on the internet, the brokerage firm name must be placed adjacent to, immediately above or below the point of contact information for your name. So the point of this is you can't put your information at the top and the brokerage contact information at the bottom buried in somewhere. It is the expectation that that contact information will appear somewhere close in proximity, above, below, or adjacent to the firm name. Okay, so those are the requirements of the individual advertisement rule. So a few years ago, the Real Estate Commission started looking at the increase in teams in Florida. And they were dismayed because teams were, in their opinion, they were kind of getting out of control in terms of how these teams were operating. Members of the public were dealing with teams, thinking that teams were brokerages. They loved the idea of branding, but not to the extent that the public was confused about who it was they were dealing with. And so they created Rule 10.026. Now, Rule 10.026 for teams is not a substitute for 10.025. It is in addition to. So you still have to also follow the individual advertisement rule, but as a team, if you, and this is not just for, a multiple person group, they define what they mean by team or group advertisement. So if you are an individual, don't stop listening to me right now. Because team or group advertisement means the name or logo used by one or more people, one or more individuals. And they did that because they wanted to make sure that it was clear that this could reach an individual person who holds themselves out in the public as a team or group. Okay, so whether you're one person or multiple people, or you start off as two, but you end up as one, you are still considered a team for purposes of this rule if you hold yourself out as a team or group to the public. So teams or group must perform real estate services under the supervision of a brokerage. You are certainly a branded entity, but for licensed law purposes, you are still performing services under a brokerage. I don't care how well you drafted some contract to operate, like some operating agreement with your brokerage, you cannot contract out of 475 obligations. Remember that. Each team or group shall file with the brokerage a designated licensee to be responsible for advertisement compliance. That does not alleviate responsibility by the other members of the team. It's just the real estate commission investigator wants to know who it is they're going to work with once they walk into the office. They want a starting point. That doesn't relieve everybody else. So keep that in mind. And then at least once monthly, the registered brokerage must maintain a current written record of all the members of that team. So that's a broker responsibility. Brokers, you either need to figure out internally how you're going to do that. Are you going to put the burden on the team to file that with you, or are you going to actively go out and request that each month? But every month you need to either have them provide you a roster or some indication of the fact that that has not changed. Team or group names. This part of it gets to the heart of why we even have this regulation. Team or group names may include the word team or group, but it is not required. It's a great idea, but it's not required. However, there are words that are not permissible, that are absolutely not okay in the commission's mind. These are words like agency, associates, brokerage, brokers, company, corporation, or other kind of business entity terms, properties, property, realty. And this is it tells the story of why we have this to begin with. Or similar words suggesting the team or group is a separate brokerage or entity. That's why we have this whole rule to begin with. And it again applies to all advertising, everything. This is the other important part of this rule. In all advertisements, the team or group name shall not be in larger print than the name of the registered brokerage. That is crucial. That was a big sticking point for the Real Estate Commission. And the advertisement must be in a manner that a reasonable person, not someone in the industry, but just a reasonable person, a buyer or seller, knows that they're dealing with a team or group. So that's really, really important. One of the reasons we're working that back into the legal updates is because when the commission rolled out this rule, they updated their broker office inspection form to add for the investigators who come into brokerage offices to inspect, to ensure that they review ads in the files or that they can observe in the broker's office to ensure compliance with the team advertisement rule. Once COVID hit, they stopped doing office visits and inspections for obvious reasons. They started again in September. Now, my understanding is those are taking on a different version, a different approach, but it is important for brokers on this webinar to know that the Real Estate Commission has again started doing office inspections, and now they will start again checking your files, your information for advertising compliance. So that's why we're adding this back. Clear cooperation is another aspect of advertisement that you need to be aware of. This has been adopted for a year now by NAR. It has been effective for months now, but just as a reminder, this is the language of clear cooperation. Within 1 business day of marketing a property to the public, the listing broker must submit the listing to the multiple listing service for cooperation with other brokers. And it goes on to define what public marketing is, and it is a very broad definition. A flyer in a window is considered public marketing. So I'm sure you're all aware of Clear Cooperation 8.0, but just in case you're curious or brand new, I want you to make sure you familiarize yourself with this language, go through, make sure you're checking it on this. And this is defined as broker, not broker. I'm a broker and I have 10 offices and I have multiple licenses. You cannot go out of that particular brokerage, is the way that NAR interprets that. So branch offices, I understand that may be a little bit different, but if you have, 5 companies spread out across your region and they all have different corporate license numbers from the Florida Real Estate Commission, sharing internally within that one corporation without, or that one corporate license without going outside publicly is fine on your, however you do that internally. But once you cross brokerages to another brokerage, even if it's the same man or woman who is the broker, if there is a different CQ number from the FREC, you are triggering Clear Cooperation 8.0. So keep that in mind. Another area of advertisement that we're seeing lots of liability relates to fair housing. The #1 area for lawsuits against members right now is where members place in their advertisements or place in the multiple listing service comments that then gets broadcasted out, comments such as no criminal history, no felonies allowed. That is the reason, the #1 reason for lawsuits right now. And it is based on a theory that it has a disparate impact against people in minority statuses because of the realities of our criminal justice system. HUD issued a memo in 2016 saying that there is when you have a broad blanket policy where you refuse to rent to someone who has a criminal history, then you are unintentionally discriminating against people in protected classes, okay? We have talked about that as an industry. There is a video on the Florida Realtors website about that. If you are a property manager or you do leasing, I need you to watch that video, because if you are putting in your advertisements, if you are putting in the MLS, any comments such as no criminal history, no felony, you're probably going to end up getting a lawsuit. If you have questions about that, I need you to call us on the hotline. What I need you to do also is to be mindful that for fair housing purposes, you want to advertise in a way that does not suggest that by phrases or words, you are in any way suggesting that you are limiting housing to a particular group, okay? In South Florida, no Section 8 violates source of income protection. There are phrases that are absolutely okay. There are phrases, and HUD has said so. There are phrases that are like the kid with his feet inside the house, but his body outside, that are okay, but you probably want to stay away from them because they may get you sued. And then there are phrases that just should be avoided at all costs, okay? So we have information on that, and I want you, we don't have time to go through all of that today, but I want you to take a look at the resources, and I'm going to link to them in just a moment in the next couple of slides. You may have heard a lot of discussion lately as a part of NAR's discussion on social justice and fair housing about the phrases walk-in closet and master bedroom and things like that. Well, NAR has taken the position based on their interaction with HUD that master bedroom is not a fair housing violation, and neither is walk-in closet. So I want to clarify that based on what NAR's position is there. But at the same time, there have been some multiple listing services, much like the kid, who've said not even worth having to defend. So they have changed fields to say things like, instead of master bedroom, they've said owner's suite. I think some of them have said. So, you know, it's up to you if you want to get close to the line, change it just to avoid any possible argument in your advertisements. I'm not advocating that you do, just letting you know that that's a big topic of discussion right now. But NAR's position is walk-in closet and master bedroom is not a problem. All right. If you have questions about this, you always can call us, but there is an article that we wrote May of 2020 that you can link to. This is on our website. And if you go and take a look at this article, we get into a little bit more detail about the things that I just talked about. So take a look at those. Now, I want to talk to you about presenting offers. We'll leave advertisement for now because I want to leave time for questions. Presenting offers. This is another big issue right now. I want you to be aware that there are some, this is another area that you have to look at FREC, you have to look at the code, you have to look at contracts like your listing agreements. As listing brokers, I want you to have discussions per the code of ethics, per the guidance here, with your sellers about the presentation of offers, because this is something that really should be driven by your seller. Remember, this is what it says here in the Code of Ethics and Arbitration Manual. The decision about how offers will be presented, how they will be negotiated, whether counteroffers will be made, these are decisions that should be made by the seller and not the listing broker. If you stay guided by that principle, you will be safe. And get the seller's instructions to you in writing so that if a Code of Ethics complaint is filed, if a FREC complaint is filed, if you are sued in any way, you have the seller's direction to you documented. Okay, this is coming up a lot because of the multiple offers that brokers are being forced to handle. Just make sure that it is the seller making the decision, okay? When taking the listing, this is the third bullet point here, explain to the seller that receiving multiple offers, competing offers is a possibility. Have that discussion affirmatively at the time of the listing. And explain to the sellers the various ways to accept those offers or to deal with those offers, okay? Does the seller want to accept the best offer? Do they want them in the order that they received them? Do they want one at a time, just the highest offer in terms of price? You know, what is it that the seller wants? Do they want cash offers first? Do they want financed offers that are, you know, what is it that the seller wants? Get that in writing and you'll be fine. From a FREC perspective, it is very consistent with the code. If you are a single agent, this is directly from the Real Estate Commission statutes, you present all offers and counter offers in a timely manner, unless a party has previously been directed in writing by the seller. Okay, so you're going to give all offers, but maybe the seller says to you, I don't want to deal with all of this auctioning and all of this stuff. I only want the highest offer. Give that to me first and I'll take a look at it. If that's the case, you want that in writing because FREC says your obligation is to deliver all offers, but you'll find if the seller tells you otherwise in writing. Okay, just remember that. Same with the transaction broker duty. Present all offers and counter offers. unless directed in writing by the seller. Okay. Now, a year or so ago, remember the Code of Ethics changed. This is the standard of practice 1-7 to clarify the issue about the presentation of offers. It provides that the listing broker, you are obligated to respond in writing, and then they add it later within a reasonable time without telling us what that means, to any cooperating broker's written requests to confirm that the offer has been presented to the seller, okay, or not. So just keep that in mind, because a lot of people will call us and say, I don't think they conveyed my offer. And so we tell them, then you have the right as a realtor to submit a written request to the listing broker to confirm whether or not the offer has been submitted, right? And they have an obligation to send that back to you in writing. So make sure you are following this, because if not, then you're violating the Code of Ethics. Couple of new things here, or one in particular that I want to talk to you about that's getting a lot of attention lately, and it's dealing with love letters from the buyers. I don't know if any of you are seeing this, but there's a big trend lately for buyers to write love letters to the sellers because there's so much pressure. These buyers are in a tough spot. Sellers are getting multiple offers. It is a complete seller's market, and buyers are looking for ways to distinguish themselves. So they are writing these heartfelt letters to sellers about why the seller should choose their offer. Dear seller, I don't know if I'm your highest offer, but I've given you my best. I really want this property. I am moving back to the Panhandle that I love so much to take a job as a teacher at my high school that I graduated from. I love Pensacola. It's a great city, and I can't think of any place better than to raise my children. Sincerely, Juana. Okay? That doesn't suggest anything about me, about who I am, other than that I grew up in the Panhandle, okay? Probably not an issue. When my offer gets rejected, I have revealed nothing about myself to suggest that I was discriminated against, because there was nothing in my letter that suggests that I'm a member of a protected class. However, same letter, except I put in there that I've moved back to teach at my old high school, the inner city high school that I graduated from as a child growing up in the tan yard in Pensacola, you know, in a impoverished neighborhood. I went to the IB program in Pensacola, and I was one of 2 Black kids in my classroom very frequently. I went to the IB program, and it changed my life. So I feel inclined to go back and teach, to offer other kids just like me an opportunity. Okay? That is a great story about me personally. But what it often says, or what it reveals about me, is the fact that I'm a Black woman. And that, once my offer is rejected, may make me wonder, was it rejected even though it was a cash offer because I'm a Black woman? So this is what we mean by be careful with these letters. Some brokers across the country have adopted a policy of not accepting these offers, or certainly not accepting the letters that go with these offers. But you want to be careful here, right? If you represent the buyer, you may want to say, I can't represent you if I'm going to facilitate these offers. Or maybe if you're the buyer's agent, you still do. That's up to you. But where it's critical because of the exposure that could be faced is from the seller's perspective. If you are the listing broker, I would have a conversation with my seller about whether or not they want to accept these love letters. And if they do, I would say, listen, it is very possible that by doing so, you move from the cut and dry sell and purchase contract legal document to very personal information about a buyer that could expose you to allegations of a fair housing violation. Do you still want these, yes or no? And you want to document their response. If they say yes, you got to think about the fact that you're exposed there. It's up to you what you do with that, but you're exposed because the buyer could allege discrimination. If they say no, you want to get that in writing and talk about how you handle those offers. When the offer comes in, are you going to say to the buyer's agent, I have instructions from my seller that I cannot present this offer with this letter attached. Would you like for me to present the offer without the letter? So have that discussion with your seller, but get their direction to you in writing. Pay attention to that area. It's coming, it's growing as the buyers find, they get more and more desperate to have their offer distinguished in some way. Calculating time, really quickly. Sure, most of you on this call understand this. I have no doubt, but just in case, time is of the essence in these contracts. When you call us on the hotline, we really have to talk to you about the specifics of the contract that you're using. We have a policy. We do not interpret contracts that are not our own. And so it's gonna be tough if you're using something other than one of our contracts. It is more complicated than you think. And so I want you to look at the contract you're using, but I also want you to look at the period that you're calculating because they're sometimes defined very differently. The offer is going to sometimes offer and acceptance will have a very different way of calculating time, and it's usually written in a different place than the standard periods like inspection period and financing period and things like that. So, and make sure that you tell us exactly what it is you're trying to calculate. Don't just say, is it business days or calendar days or how many days, do I have to perform? Tell us exactly what you're trying to calculate. Now, for the purposes of this discussion, I'm going to use this language because this is the most commonly used language in the state. This is our FAR language. And so we talk here about the effective date. We have a very different way of calculating effective date. And this is where we get the most questions, not the time periods, okay? Time periods people kind of get, 15 days or 20 days or whatever, they get that. It is whether you have a contract to begin with that is often hard for people to understand. So we say here that the time for acceptance is not a deadline for the seller to respond. It is a countdown to a withdrawal. That's kind of how we characterize it here. And this is our language. So I'm going to give you a scenario, and then I want you to, we're going to walk through whether or not what the effective date is, what the date of acceptance is, or the date of the contract and the time period. So, because we're getting short on time. If the buyer submits a signed offer to the seller, they submit the offer on Monday, March 2nd, 2020. The seller signed the offer without changing anything, and the seller delivered the fully executed offer back to the buyer the same day at 10 o'clock that night, Monday, March 2nd. They provided in the contract that there was a 15-day inspection period. I want you to think about what is the effective date of the contract and when does the inspection period end? Now, going back up, the effective date, this is what the contract says about the effective date. It is the date of this contract when the last one of the buyers and sellers has signed and initialed and delivered this offer and counter offer. That's the effective date. Under our facts, the effective date is March the 2nd. Okay, y'all with me? The reason is because it was signed, go back to the language. It was signed, initialed, and delivered on the 2nd. Yes, after 5 o'clock. We didn't say it had to be back by 5 o'clock. Don't get caught up in that. The only time 5 o'clock matters is where the contract deadline ended on a week, on a Saturday, Sunday, or it was extended to a Saturday, Sunday, or legal hot down. It then extends to 5 o'clock the next business day. In our case, we weren't dealing with Saturday, Sunday, or a legal holiday, okay? So we were dealing with a Monday. So 5 o'clock is not relevant. Okay, so don't get caught by 10 o'clock. We get that all the time, but they didn't send it back until after 5 o'clock. If it wasn't a Saturday, Sunday, or legal holiday, it doesn't matter. The effective date is March 2nd in this case. The inspection period ends likewise at 11:59 on Tuesday, March 17th. Not 5 o'clock on March 17th. If the inspection period had ended on a Sunday, then the following Monday at 5 o'clock, the inspection period would have ended. But it did not in this case because it was a Tuesday. Okay. The takeaway here is don't get caught up on 5 o'clock unless it ended on a Saturday, Sunday, or legal holiday. And pay attention to the delivery of the contract, the acceptance, not the signature. All right, those are the two big takeaways with calculating time. And the last thing I'm talking about really quickly, because we've talked about this before, although there's a new law, so we're going to do a slide on the new law. Assistance animals. Now I use this term instead of emotional support animals on purpose because federal law uses the phrase assistance animals. So let's talk about the vocabulary. Language matters. Assistance animals is a term the federal government uses to include both service animals and emotional support animals. But they're two different types of animals. Emotional support animals are covered under the Fair Housing Act. Service animals are covered under the Americans with Disabilities Act. Talk about that in just a second. This is, you've seen these slides undoubtedly. This is Prima Donna. This is a New York Times article about an emotional support animal case right here in Florida. And I'm sure you've heard this presentation, and I'm gonna again beat this horse. And I do so because again, you've got to separate out these assistance animals from pets. Dogs, ducks, even insects can qualify. Under the ADA, really well defined, these service animals. Dogs, miniature horses. They perform a valuable, vital life service for their owners, like seizure dogs, seeing eye dogs, we are really clear on what service animals do. Emotional support animals, not quite as defined, and that's where we have the confusion. Emotional support animals, they still perform a vital service, but they provide emotional support to their owners. And so they don't have the same type of definition when it comes to the type of animal. It can be an insect, or as you know from the last slide I'll show you, it can be an alligator, okay? Just keep in mind that we all know that there is abuse here, but the guidance from HUD is really clear. These animals are not pets. Pet restrictions cannot be used to deny or limit housing to people who need these assistance animals. Housing providers must grant reasonable accommodations in such instances. Must grant, not may, must. If a tenant has a physical or mental disability that's substantially limits one or more major life activities, then the landlord must grant that reasonable accommodation. You cannot exempt this tenant by using pet policies. You can't apply pet deposits. You cannot charge extra rent for having that service animal or emotional support animal, because they're not pets, so none of that applies. What can you do? Well, if it is apparent, if the need for the animal is apparent based on the disability of the tenant, then you do not ask for supporting documentation. If it is not apparent though, then you have the right as a housing provider to ask for documentation. It can be in the form of a letter from a physician, a social worker, even a psychologist, but understand you cannot ask for medical records. The letter would just simply say that the tenant has a need for the animal. That's all it says. Now, this letter has been the source of lots of abuse. And because of that, Florida has a new law effective July 1st, 2020. A tenant who misrepresents the facts regarding the need for a service animal, or even a provider who helps the tenant misrepresent the facts, is committing a second-degree misdemeanor. No more going online buying certificates from somebody you don't know. The certificate received through a website itself is not enough to establish the need for an animal. Now, it doesn't mean they can't get it from offline, because telemedicine is real, right? I just had a telemedicine appointment with my doctor this week. If someone, so they can, it's just that they have to have a pre-established relationship with that provider who is documenting the need for the animal. Can't just be somebody that they've never seen and that they just connected with out in California online. If someone needs more than one animal, they have to have documentation for each animal. But just be careful. This is not a license for you or for the owner or the association to simply start to put up roadblocks for the tenant. There needs to be extreme care that you use in order to ask for this documentation. To help you better understand all of the nuances, there is an article on the website that we released July of 2020. There is also like one of our Take 5 videos that you can look at to better understand all of the ins and outs. It's great to play it like your office trainings or post or send to your agents. So take a look at that. It will really help you understand all of the ins and outs of the bill, or now the new law. And when you feel bad, when your owner is giving you a hard time, and make sure the owner is making the decision, not you. It's just like the listings and how to handle multiple offers. These are decisions for the owners or the association. You shouldn't violate the tenant's law rights, even if the owner says, I'm not written to that person and that pet. That's not your decision to make. Let the owner make the decision. Caution the owner that they may be violating the law. They should speak to their attorney, document your file accordingly, and convey to the tenant the owner's decision, not yours. I would even say, show the owner the story of Wally the alligator and say, good luck with your decision to deny in light of the fact that Wally is an emotional support animal. All right. So that being said, let's stop sharing the screen and answer questions you have about these issues or anything else that you have questions about. And yes, go notes. What questions you got? Let's see. I see a couple in the chat. Where are your questions? Where are your questions? Give me your questions. I know you got questions. Thank you, Angela. Angela said this was an awesome course. They had Joel teach the 2-hour course. Thank you very much. So is adults only okay then? That's a great question. This is one we get comments about often. So this goes back to the question about the advertising red, yellow, and green and whether adults only is okay. Adults only can be okay. So familial status is a protected class under the Fair Housing Act. What that means is people with kids, families with kids. You cannot discriminate against families with kids. However, if a property is a legitimately designated community for the elderly, so a pure 62 and older community where there are no children, or a 55 and older community where it is formed and designated that way, where they are allowed to have up to 20% of the units occupied by kids, but maybe not, it's up to them as a community. You may advertise it as adult only. What I would say is not adult only. I would say 55 plus community or 62 and older community, whichever it's designated as. But make sure you get something in your file at the time you list that property to ensure that it is truly that and not just the preference of the community, right? Because if it is formed that way, there are actual filings like declarations that are on file with the state that you can get and put in your file to ensure that you are not discriminating inadvertently because of a representation of the owner. So yes, adult-only communities do exist. They are legal if they are filed and not just the preference of the neighborhood. All right. Can counter offers presented via email trigger the 2-day extension of time for acceptance? So via email. So let me, I don't have the contract form in front of me. I apologize. Here I go. It depends. So an emailed counter offer where it is just an email, that's not going to work. In order to be effective, things must be signed by the parties. Electronic communications between the parties is acceptable. That's what Form Simplicity does, right? It is an electronic, paperless way of facilitating a transaction. When I see email, I think to myself, because you say here with bullet points of the main terms, that's not going to do it. It needs to be the contract signed by the parties, and it can be electronically signed by the parties. That is then subsequently emailed or transmitted electronically. But just an email, that's not going to work. Statute of frauds requires, here in Florida, requires to be binding, contracts must be in writing, signed off on by the parties. So the email informal route won't work. On pen advertising, do you need to have the office number or just your cell okay? So on a pen, you don't have to have any form of contact. That's up to you. On the internet is where the point of contact information becomes relevant. Just on the internet is where the FREC regulates that. On the pen, it's up to you what you put on there, so long as you have those other components as required by 10.025. House ad said the roof is lifetime metal roof, but it turned out to be a double roof, metal shingle, metal above shingle. It's the listing realtor against the advertising law. So all ads, so it's what it says is ads cannot be false, misleading, or deceptive. That's false. So arguably the ad is false. In that instance, much of that will turn on what the realtor knew. This is why it's so important. It would be a dangerous industry if realtors were held responsible for every aspect or representation of every aspect of the property, right? So let's say that the realtor advertised that based on what's on the seller real property disclosure form. If someone filed a complaint there, what typically happens in FREC world is FREC, assuming that gets investigated, the realtor who's investigated has a right to file a response to the investigation. And if they can produce something in writing from the seller showing that that was a representation that they made based on that seller's information, they probably will not get prosecuted. That won't get past a probable cause panel, right? That's why it's so important that you all document, document, document. Now, if the realtor took it upon themselves to assess that and make that determination, then they're in trouble. So document, document, document. So if the seller, though, did not disclose that and the realtor determined it, I'm not sure if I understand from the question when it's being asked, what should you do if a seller doesn't disclose a material aspect of the property? My apologies, I'm gonna grab some water. Sellers are obligated, so are agents, to disclose all known facts that materially affect the value of the property that are not readily observable to a buyer. Ironically, that legal standard was created based on a case about a roof, Johnson versus Davis. Anytime there is a concern that a seller did not disclose something material in a transaction or that they misrepresented something, then Johnson versus Davis may apply. Every single disclosure case is factually different. So I would encourage you, if you have any type of Johnson v. Davis disclosure case, call us on the hotline so we can talk it through because every case is different. Can you file a complaint against a listing agent for non-disclosure? Yes. I can't go back because I stopped sharing my screen, but in that where I had the list of duties for single agent and transaction broker, where we were talking about presenting all offers unless otherwise disclosed, unless otherwise directed in writing. One of the other duties on that list is to disclose all known facts that materially affect the value of the property. So it is a seller's obligation as well as a broker's obligation and an agent's obligation. So anytime you feel that there may not have been proper disclosure by an agent, you can file the complaint. And again, FREC will investigate and look to see, was it something that the seller just didn't disclose to their listing broker or misrepresented to them as well, or not. So that's kind of how that works. Public records identify the property as condo single family. It qualifies as a villa, single family, or condo on the MLS. Member says it's single family. Can I advertise it as that? Or MLS says I can use single family. So this is common. Here's one of the interesting things about having been on both sides of the industry. MLS does not cooperate with FREC investigators. And rightfully so, right? They are not going to give up the MLS information unless it's a peanut, and even then, you know, and that's just kind of how it works. So, and even when FREC gets cases involving MLS, you know, there's that disclaimer at the bottom that kind of says, you know, you must verify this information, that kind of thing. Now, that's not a license to go out and just put any old thing in the MLS, because you're going to be held responsible ultimately, right? But I will say this, part of the reason for that disclaimer is sometimes you do get these interesting things with public record. A lot of times is it 4 bedrooms or 3? Is it 2 bathrooms or 2.5? Can't really tell. One thing listed, the square footage is a huge one that we get questions about all the time. So I would say if ever you have a situation like this where the public record is inconsistent, where you have these different sources that you can't really tell how the property is classified like that, pick the best one, but in the notes, and talk to your MLS about this, because every MLS is different, right? They're independent, but talk to your MLS about just putting something in the notes to put the reader on notice that there is some confusion with public records. You know, note, please verify the classification of the property in public records. Just, you don't have to, and that's the thing, you're not making representations, you're conveying information. And all you really need to do is just cover yourself by putting the reader on notice that there is at least some confusion in public record that they need to verify, and then you're covered. Anybody else? Anything? Use me while you got me. So last question. If listing agent receives offer packet with love letter, but doesn't know there's a love letter being sent, and seller has said he does not want to see love letters, do you just return offer packet to buyer? So this is the issue, right? This is where you really want to be proactive in how you're going to address these as a part of the listing. So if the seller has said he does not want to see love letters, you may want to also have the second part of that discussion with the seller, where you say to the seller, then do you want me to return the offer and the love letter? Or do you want me to ask and have them resubmit with just the offer? Because the last thing you want to do is not convey an offer without the seller's permission, right? And if they say yes, then what you do is then say to the buyer's agent, the seller has told me they do not want to see love letters. Please resubmit this offer without the love letter. Okay, that's how you handle that. But that requires a proactive approach to how you're going to handle these. Or you can do it individually. That's fine. It's just, you know, it's easier to know what your seller's wishes are with respect to these. If you're getting them. If you're not getting them, then that's fine. But certain areas of the country are getting far more of these than others. And yes, you can always file a complaint against inspectors. They are also regulated by DVPR. Can you put in MLS realtor details that you don't want love letters? Talk to your MLS about that. I was on an MLS administrators session with NAR yesterday because NAR's conference is going on. I believe they were talking about this love letter issue there as well. So lots happening there, lots of discussion going on with that. So some MLSs may start to address that. With that said, thank you very much. Oh, thank you. That's so sweet. Our time is up today. I appreciate you all so much for allowing me the privilege of serving you. The hotline attorneys feel the same way. Florida Realtors feels the same way. Margie sets that tone. Our officers set that tone. So thank you. If you need us, please call us. If not, y'all please stay safe as these COVID numbers rise. And we're here for you. Our motto is your success is our business. And thank you. Have a fantastic rest of the week.